Shannon O'Connor has just been found guilty of most of the 20 felony and 43 misdemeanor counts she was facing, resulting from the alleged activity that's said to have started back at the height of COVID lockdowns, mid-2020. It's said to have gone on for at least a year or so. O'Connor was arrested and has been held without bail since October of 2021. The case itself started 4 months ago. She is expected to face jail time. Our Jesse Gary is still in court. He's been bringing us updates as the jury has been returning the verdict count by count. He also was able now to hear from the mother of one of the alleged victims. According to Jesse, this woman said, "You never know who you're having tea with across your dinner table. She is a predator. A mom can be a predator, a stalker, a groomer, and a harasser."
A mom can be a predator. Well, this victim's mother must not listen to DU. She must have not been a subscriber to this channel, because that's essentially a lot of the criminals that we follow here is innocent moms organizing parties like Mayor Misty, who went to a teenage alcohol-fueled party and is partying it up, gets drunk, has sex with a 16-year-old like it's, just another day. Order DoorDash herself a Plan B pill to make sure she doesn't get pregnant, have a conversation with the victim's mother and say, "Hey, yeah, we had sex and everything, but I took a Plan B pill. I'm not going to get pregnant." And that was sort of, let's keep this thing under wraps and silent. Not for party mom Shannon O'Connor. This thing blew wide open. She flees to Idaho, where she starts organizing more parties and is found with a dozen more kids in her house, and essentially was arrested in Idaho, extradited back in 2021. Yeah, baby, this thing has been going on for the better part of a decade. And let's go to the district attorney himself, who could not stay away from the cameras on this one.
After many years and many, many victims, today there was justice. It was a long wait. It was a long trial. There was a lot of hardship and pain and suffering. But with the jury's verdict today, there is now justice. Defendant Shannon O'Connor was convicted of more than 60 crimes against more than a dozen child victims from Los Gatos. Every child who testified, the jury convicted the defendant of a charge involving that child. The charges included child endangerment, annoying and molesting a child, dissuading witnesses from testifying, and facilitating the forcible sexual assault from one child on to another child. We expect as parents that we protect children, protect our children, protect other people's children. This defendant took advantage of children, manipulated children, hurt children emotionally, mentally, physically, and did that for her own perverse reasons. And today there's justice for what she had done. It's important to recognize the victims who testified and their families, their parents who supported them during this very difficult ordeal. This case does not happen if the children do not come forward and stop what this defendant was doing. Without the children, the conduct continues. So our first thanks and appreciation is for the child victims in this case who came forward. Secondly, this is a case that few law enforcement agencies other than the District Attorney's Office Bureau of Investigations could investigate. There were hundreds of individuals interviewed. There are terabytes worth of information. phone calls, jail calls, videos, social media. And investigator Christina Hanks from the District Attorney's Bureau of Investigation was the lead investigator and brought all of this evidence together. Without her, this case doesn't happen. And then also standing with me are 3 prosecutors on this case. This case began with Rebecca Wise, who's standing to my right, who did an enormous amount of work on this case. She's such a good prosecutor, I then promoted her, and we then handed this case to Joanna Lee and Morgan Willis. And they put together a powerful and compelling presentation to the jury in a trial that took months, 4 months to try this case, 63 counts, more than 20 witnesses testifying, just a tremendously complex case. And they put it together in a very strong and compelling way, which allowed the jury to come back with a verdict of more than 60 guilty counts, and the defendant looking at decades and decades in prison. Because of Joanna's efforts and Morgan's efforts, there's justice and there's accountability.
Okay, that is Santa Clara County District Attorney Jeff Rosen, who is on a victory tour after years of his office staying on it on this case. All of these kids now are in college or graduated. The last thing that young adults want to do is go in and be a snitch and uncool and talk about how this out-of-control, predatory, perverted mother facilitated them drinking a bunch and having sex when they were kids. And yet they did it. And more than 24 of them did it and came forward. And that is incredibly difficult for a prosecuting office to gather that much evidence and that many witnesses in cases like this, because people simply were using the statistic 99%. There are Shannon O'Connor, party mom, being caught as part of the rare 1%. 99%, prove me wrong, of moms that or dads that contribute to this environment, engage in inappropriate conduct, and sexually abuse their sons, daughters, friends, is significant, I would say. And party mom is just part of the 1% that was caught and drew this sucker out. And then up to bat is, in response, Stephen Prokosky, sort of a character who has spent years dealing with party mom. And this case, he's coming out charging on a lonely island.
I am the appointed counsel for Shannon Marie O'Connor. We are still mid-trial, as I think all of you understand. We just got a very, what I would characterize as a disappointing verdict. We got about 48 decisions from the jury. About 4 of them were favorable to Ms. O'Connor. I appreciate the jury's diligent efforts in this case. They were not exactly it's obviously not the result we were hoping for. They were also not, the not guilties that we achieved were not the not guilties that we in particular argued for as our highest priority. So we were obviously disappointed. I'm going to keep my comments relatively limited at this point because we are still in trial. We have a bifurcated trial this afternoon. That's essentially a separate trial on what we call the aggravated counts, or the aggravating factors in the case. The district attorney has to plead and prove all aggravators in the case. They have to do with criminal sophistication and particular vulnerability of the victims. The point of the aggravators is that they would enable but not require the court to essentially max Ms. O'Connor out within the sentencing ranges. I don't want to get too technical or deep into the woods, but that's about all I'm going to say. Since we are still mid-trial, since I've got about an hour and a half to prepare the next part of the trial and some important responsibilities. And then after that, we still have yet to be sentenced. And so we've got a lot of work to do. I certainly don't want to say anything inflammatory to the sentencing authority that she will see later on tonight. So I think I'm going to wrap it up with that. Thank you, everyone.
Is she going to jail? Is she going to jail?
She's already in jail. What do you mean? Is she going to jail? She's been there for 5 years. What are you talking about?
What's the maximum charges that she might, or the maximum amount of time that she could face?
It depends. It depends on whether or not you consider the misdemeanors as something that could be assigned consecutive to the felonies or not. That would be unusual, right? My hope, my honest hope and expectation is that for all the misdemeanor convictions that she suffered, she would be given a concurrent 1-year sentence and credit for time served on those. It appears to me that the max on the felonies is something in the range of about 27 years. Okay? And someone asked me to spell my last name. The last name is P like Paul, R-E-K-O-S as in Sam, K-I. P-R-E-K-O-S-K-I.
That's Stephen with PH?
Stephen with a PH, thank you for asking that. I appreciate that.
She was guilty finding on sexual penetration of a person while intoxicated.
Correct.
She was not the person who committed the act. Can you explain that to us?
The district attorney had what I called in my arguments sort of unusual, attenuated theories of guilt that had to do with my client not being the direct perpetrator of the sex acts in the case. She was charged alternatively as an aider and abettor, or as the employer of an innocent agent. An innocent agent's like a dupe. You know, like if I ask you to carry my attaché case to Colombia, and I tell you it's only got papers in it, and it turns out to have a kilo of cocaine, you are my innocent agent. So yes, your question recognizes that my client did not penetrate personally, did not sexually assault personally any of the children, and the district attorney employed, as I said, what I call attenuated theories of liability. Nonetheless, the jury convicted her of those. There were 4 of those counts. 2 of them were misdemeanor and 2 of them were felony.
Why was it so important for you to only focus on certain of the charges in your closing arguments in defense? And what does that say that they all ended up coming back in this case guilty?
Well, it says that I failed, right? That I failed to connect and convince the jury of those particular arguments. There are multiple reasons. Some of them are technical, having to do with the import of the strikeable allegations, right? We fought the strikes, for one thing. The strikes affect the percentage of time that the litigant has to serve in custody. The other thing is that we attacked a weak, attenuated theory of liability, right? On 4 of the 5 counts that were sex counts, as this gentleman just recognized with this question, my client was not the direct perpetrator. That's unusual, right? I've been doing this for about 28 years. I've never, ever done a trial where a sex offender was charged as an aider and abettor or was charged as the perpetrator via the use of an innocent agent theory. And I think I think it's clear. We told the jury that's why we went to trial on this case. We went to trial on this case not because we were trying to say that my client didn't contribute or provide any of this alcohol. And that's the answer to the second half of your question. The reason why we effectively conceded the bulk of this case in the opening statement and only fought some counts in a very general sense is because we thought that we would lose credibility with the jurors if we tried to present a defense that denied that my client provided alcohol. We think that what happened was a progression of the provision of alcohol. We think what actually happened was at the beginning, my client wasn't providing alcohol at all. And we think that in the beginning, there were multiple places where the children were going where alcohol was provided. What ended up happening, though, ultimately was because the path was so easy at the O'Connor household that those other locations were dispensed with and all the alcohol imbibement happened, not all, but much of the alcohol imbibement happened at the O'Connor household. And so while we thought that the district attorney's theory, which was essentially all bad all the time, as bad as you could imagine it, wasn't entirely accurate, we didn't think that dying on the hill of Mrs. O'Connor didn't provide the alcohol at the first party, right? There was credible testimony about the first party that the children snuck the alcohol out of the liquor cabinet. My client didn't know anything about it. The district attorney quibbled with that, and that's fine. But as a tactical proposition, what we were faced with was standing in front of the jury and telling them that my client didn't provide the alcohol, and we didn't think that that was a smart thing to do. You know, we thought that, as I said, that was a credibility challenging position to take. And so we consistently identified the 5 counts in the beginning of the case that we thought we would defend, and the way that I explained it to the jury was specifically, we would defend these 5 counts specifically. Those had to do with the 4 sex counts and the 1 dissuading a witness count, which we thought failed with regard to the evidence. The jury obviously disagreed. And then the other counts that we fought, we described to the jury that we defended them more in a general sense, because there were the child endangerment counts had a contingency about them, right? They were serious if the jury found the victims to be in danger for their life and limb, essentially, and they were not as serious if the jury found that the children were not in danger for their life and limb. Essentially, great bodily injury is the phrase, the term of art. The jury agreed with us on 4 of those, right? Where the district attorney had charged in 4 separate incidences that the children were in danger of great bodily injury or death, where they followed our suggestion that, in fact, they were not in danger for great bodily injury or death. And while I appreciate that, as I said, it wasn't central to the 5 counts that we defended. And at the end of the day, it helps a little bit, but not a lot.
How was Ms. O'Connor feeling after this verdict came down? Did she say anything to you? Did you say anything to her?
She's crushed. She's very, very disappointed. Yeah, I don't think I could say it any better than that. I'm not going to say what she said to me, but she said some things to me as the verdicts were progressing that made me understand that she was deeply disappointed in the decision.
Poor Stephen Prokoski, spelled with a P, after his client, party mom Shannon O'Connor, is convicted of most all of the more than 63 charges against her. She will face possibly decades in prison after spending more than 5 years in jail awaiting trial. She waited and waited and waited, and that's what she waited for. The jury took days to come to this conclusion. No doubt, having that many charges and dealing with that many jury instructions, they clearly did a thorough job, and they did give Stephen Prokoski, spelled with a P, a few wins, but not the wins that he wanted, and it won't help his client that much when she heads to sentencing. That is the case of Los Gatos, California party mom. She was the coolest mom in town. She provided alcohol. She provided a big house. She provided rides. She was on Snapchat. She was all over social media. And by some accounts, she was a huge misogynist in which she could care less about the young girls that were heavily intoxicated and being sexually assaulted and abused by young teen boys who she also got drunked up and sent them in rooms together without a care in the world, would talk about the attractive girls at that age, would talk about the attractive boys at that age, and essentially served as a gatekeeper, almost as a teen modeling agency, but a teen partying agency where she was the principal promoter. So I should say teen club promoter, Shannon O'Connor, but the media around the world has used party mom. She tried to get a win. She got a huge loss. She tried to leverage that female pred complex that she is innocent. She is a woman and she is nurturing. All she was doing was trying to provide a safe environment for these kids while texting a bunch of them on Snapchat with all of her messages disappearing, with her threatening the boys and girls that they can't tell anyone and that she would get in a lot of trouble for her conduct, which turned out to be pretty accurate. Shannon O'Connor, Los Gatos' mom, will face sentencing coming up as she is found guilty on dozens and dozens of misdemeanor and felony counts by a jury in California. Stay tuned here at the Dark Underbelly. We've got this case and many more